You filed your trademark application, you're sitting in the queue right now, and you have absolutely no idea if the timeline you were quoted is actually normal. This explainer covers the real timeline for federal trademark registration and exactly what controls how long it takes.
We know the agonizing silence you're probably experiencing right now. Having reviewed thousands of applications directly from the examiner's side at the USPTO, we're going to definitively answer your timeline questions today, straight from an insider's perspective.
Section 1. The True Trademark Timeline, Realities of the USPTO Queue. Let's look at exactly how long this is realistically going to take. For a clean application that moves through the system without any major hiccups, federal trademark registration typically takes 12 to 18 months from the day you file to the day you actually receive your registration certificate. It is a slow, methodical procedure by design.
If you're wondering why absolutely nothing has happened since you filed, the answer lies in the queue. The vast majority of your overall timeline is just waiting. Right now, new applications sit for 5 to 9 months before an examining attorney is even assigned to look at your paperwork. No one has reviewed it, no one has rejected it, it's literally just waiting its turn.
There is a pretty stark contrast between internal agency targets and what applicants actually experience out in the real world. The USPTO's long-term goal for a first action is 4.5 months, and their target for the current fiscal year is 5 months. But when we look at the actual data, the average total pendency for an application that doesn't face a formal opposition is roughly 14 months.
Section 2. Navigating the 2025 fees, what the new structure means.
Since January 18, 2025, the USPTO completely replaced its old fee tiers. Now there's a flat $350 base fee per class of goods or services. But you really have to pay attention to the surcharge triggers. If your description is incomplete or non-standard, that directly triggers a $100 per class surcharge. And if you submit a custom description that falls outside their pre-approved manual and needs manual review, you'll see a $200 per class surcharge.
Section 3. Office Actions and Delays, when things go wrong.
Now let's talk about roadblocks. An office action is just a formal USPTO letter raising a legal or procedural problem with your application. This could be a Section 2D refusal, meaning there's a likelihood of confusion with an existing mark, or maybe a Section 2E1 refusal because your mark merely describes your goods or services. Examining attorneys also issue these if your proof of use is insufficient or if there are identification issues with your goods and services.
This is where the timeline really starts to stretch. An office action instantly adds at least a 3-month response window, though you can get an additional 3-month extension if you pay a fee. Plus, a second office action is incredibly common if your first response doesn't completely resolve the examiner's issues. So just one round of these problems can easily add 6 months or more to your overall waits. If you want the exact fee breakdown by scenario, along with the full response window math for office actions, we've linked a complete article in the first comment below.
Section 4. Use versus intent filings, Section 1A versus 1B.
You might be wondering if it matters whether you filed based on actual use in commerce or just an intent to use the mark down the line. It definitely matters. Both follow the exact same initial path up through publication. However, a Section 1A use-based filing registers directly once the publication period clears. A Section 1B intent to use filing, where you haven't started using the mark in commerce yet, takes a completely different path at the end. The USPTO issues a notice of allowance instead of a registration. After that, you have up to 3 additional years, grouped into 6-month extensions, to file a statement of use proving the mark is actually out there in commerce.
Section 5. Publication and formal oppositions, third-party challenges.
This brings us to the final hurdle that can severely delay an application, which happens during the mandatory 30-day publication period. A TTAB opposition is a formal proceeding where a third party officially challenges your trademark registration. If someone files this challenge during your publication window, it completely freezes all further registration activity. Absolutely no progress happens on your application while that proceeding is pending before the Trademark Trial and Appeal Board.
Because an opposition essentially acts as an entirely separate litigation process, it typically pushes the overall timeline well past the 24-month mark. We've reviewed thousands of applications from the examiner's side, and the pattern is incredibly consistent. Marks that clear cleanly are the ones where someone did the work carefully before submission. The single most important thing to take away here is that filing quality, not paperwork speed or luck with examiner assignment, is what actually controls your timeline. If you're currently mid-examination and want a second opinion on an office action, or you're about to file and want it done right the first time, the full article and how to reach us are in the first comment below.
Subscribe if you want more straight answers on USPTO procedure without having to search for them every single time. In a system where one overlooked detail can easily cost you 6 months of waiting, it really begs the question, can you afford to just file and hope for the best, rather than building certainty from day one?